they themselves are not going to take a position on this, but they're going to leave it up to the court's wisdom to make a determination, is this a valid ordinance, is this a valid measure or not. And that's the position that Mr. Atchison has found himself in discharging his duties as a district attorney. And because of that, he has found himself unable to state a position for or against this ordinance. Now, in terms of the other issue that Mr. Lilly raised, the attorney fees issue, I think that plaintiffs raised a legitimate point, and the court echoed that as well, that that may be an issue which would be reached later and may well not have to be reached or will be addressed in a different way depending on the court's determination. I would suggest, however, that plaintiffs have raised a number of subconstitutional issues, and applying the general principle that decisions should be made on those subconstitutional grounds first, that I would suggest would be an appropriate analysis here, and we may never reach those constitutional issues, which Mr. Lilly argued in his brief, would, if anything, be a basis for attorney fees. And then finally, in regard to Mr. Atchison's office's liability for those attorney fees, those are distinct from potential liability for the county or the commissioners. But I will reserve those arguments until such time as it's more properly before the court.
Thank you.
Thank you.
What I'm inclined to do today, given the number of legal issues that need to be considered, and finding that the potential harm to the legislative bodies and the fact that they would be required to start enforcing this ordinance, the expense to the public, the uncertainty and expense that would be potentially incurred by employers, the effect that it might have on other individuals seeking employment in this county, and not finding that failure to require the enforcement of this would have any significant effect on the status quo within the county. I am going to go ahead and grant the preliminary injunction that has been sought here, and I'm going to take under advisement the motion for summary judgment, and we'll go ahead and respond after I've had some opportunity to give it full consideration. Now, there is a request for an amended complaint to be filed. And does anyone want to be heard further in opposition to that motion?
I will just state simply that Council's indication that the two constitutional claims were not explicitly pled in the amended complaint stands as an understatement of the morning. They are not mentioned at all. This is not a minor amendment that just tweaks something. There are two new claims.
Right.
And with that, I don't say that.
Well, I would like to resolve this as completely as possible, and so it seems to me that judicial efficiencies would require that we allow the amendment to be filed and appropriate responses then to be made. So is there anything I need to do further as far as scheduling today?
Your Honor, this isn't a matter of scheduling, but in our request for preliminary injunction, we also asked that security be waived.
I'm not seeing that there is a need for security, so I will waive that requirement in this case.
Your Honor, also not a scheduling matter, but we've taken the liberty of preparing a proposed order, granting a preliminary injunction, as well as one for summary judgment. I've circulated those to opposing counsel. I'd like the court's permission to approach and to present the court with these.
Mr. Lilly?
I do have some comments on that, Your Honor. I received this about 10:25 this morning, so I can give a detailed read. But I point out that I believe it is both broader than is required and appropriate and narrower. It says more than it should and less than it should. If you look at the bottom of page 2, the paragraph there, there's a finding that the plaintiffs are entitled to all the relief they seek. I don't think the court needs to make that finding in order to enter a preliminary injunction, because that finding essentially is a final determination on the merits. And rather, it should be phrased in terms of some likelihood of prevailing rather than entitled to all the relief that they seek. And then further in the third line, or actually line 19, it says during this litigation we injure plaintiffs. And I think if you're going to enter a preliminary injunction, you probably need to say that there's some irreparable injury to the plaintiffs rather than just injure them.
Okay. So your proposed language, I'm assuming there would be no objection if I changed injured to, or added with irreparably injured plaintiffs?
Not at all, Your Honor. There'd be no objection to that. I would just point out, though, that I wouldn't agree with Mr. Lilly's reading. I think it's, the line 17 says it appears plaintiffs are entitled to the relief that they seek. So it's not a final adjudication. It's just simply that it is meant to track the language of the rule. I believe it's ORCP 79 for preliminary injunction. And so it would not be a final adjudication.
And what language would you propose, Mr. Lilly?
I would just say that it appears that they may be entitled, or if the court is so inclined, are likely entitled to some relief that they seek. Because otherwise you're essentially prejudging the merits of all the
I will indicate are likely entitled to at least some of the relief they seek. And with those two additions, I will go ahead and sign the order.
Thank you.
So now the second amended complaint, I believe it is, will be filed and served, and everyone will have the appropriate opportunity to respond.
I can serve it right now, Your Honor, and we'll file it
Okay.
immediately.
And so then it looks like the next important event will be my decision on the motion for summary judgment. Okay, I believe that concludes matters for today.
Thank you, Your Honor.
I sent you a copy of that, right? I have it, okay. Let me double check to make sure I have the same one, but that's the only one floating, excuse me, that's the only one floating around, isn't it?